Hello everyone, good afternoon. I'm making this video pursuant to my last week's post. On Friday, I believe I had asked you all as to what are the requirements of a valid will. Thank you for all those who responded. I really appreciate your responses, and I believe all your answers coupled together with today's talk would constitute the right answer. Now, before proceeding ahead with what would be the requirements of a valid will, let me first explain to you all as to what is a will. Now, under Section 2H of the Indian Succession Act 1925, a will is a legal declaration of the intention of the testator with respect to his property, which he desires to be carried into effect after his death. Too complicated, so let me break this down for you all. It is a legal declaration. Now, when you are writing your will, in the first 2-3 lines, I believe, you need to make a declaration. What is the nature of this declaration? I would come to in a few moments. But it is a legal declaration of the intention of the testator. Now, who is a testator? A testator is a person who is desirous of making his will, which will later be executed. So, it is a legal declaration of the intention of the testator with respect to his property. Somebody rightly gave an answer that you require property and assets. Yes, you do require property and assets if you are desirous of making a will, which he desires to be carried into effect after his death. So the last answer that somebody gave was you need a dead person. Now, that is not an essential requirement of a valid will, but I suppose what that person meant was that if you were desirous of executing a will, the person will obviously need to be dead, because, you cannot be executing a will unless the person dies. Now, coming to the moot question as to what are the essential requirements of a valid will. All of you all mostly said that the will has to be in writing. And yes, the will does have to be in writing. Oral wills are exceptions to the case, which would apply to cases like soldiers who are on the front line and who are about to lose their lives, and if they wish to say something, they could do so orally, which is acceptable in law. But for the rest of us, the will has to be in writing, preferably in your own handwriting, which would then be difficult to refute. But of course, if you feel that you have terrible handwriting, which will not be understood by anybody, then you have it typed. Now, who can make a will? Anyone who is of sound mind and not a minor can make a will. Now, what is soundness of mind? In law, a lunatic or an idiot cannot make a will. Having said that, if a person is suffering from Alzheimer's, the person can make a will, provided he is in a lucid state of mind. What is lucid state of mind? That means he is able to understand the consequences of his or her own actions. On the other hand, you and me, we think that we are people of sound mind, and yes, we are. However, when in a state of inebriation or intoxication, that means under the influence of alcohol, not able to understand what we are doing, would make a will not be considered to be a valid will in the eyes of law. Coming back to legal declaration, when you are writing a will, in the first 2-3 sentences, you need to state that you are a person of sound mind, not a minor, making this will and appointing such and such person as an executor of the will. Now, it would be ideal if you could have 2 executors. Why? Because in case one executor passes away, the other executor would still be alive to execute your will. Now, if this is your second will, because people do make multiple wills, it is very crucial for you to make a statement that you are revoking all your previous wills and codicils. What is a codicil? Codicil would essentially be an addition or a supplement to the will that you've made. Probably added something to your old will or deleted some sentence from your old will. So you need to state that you are revoking your previous wills. Now, as somebody rightly answered, you need your property and assets. What would constitute your own property? So, your own flat, your own office premise, any of the property that you own. It cannot be tenanted, because in law, you cannot give away a tenanted premise, even if you wish to. So, your own property, your mutual funds, your fixed deposits, your money in your savings account, you need to make a list of this. Now, this could be tedious and tiring. So kindly go through it again and again to ensure that you haven't missed on anything. Otherwise, you would have to make a codicil again. So, and as well as a list of people whom you need to give this to. So against every property, you need to write whom are you giving this will to, whom are you giving this property or money or fixed deposit or mutual funds to. Thereafter, the last crucial element of a will would be signatures. Definitely you need to sign the will in the presence of two witnesses. Mind you, two witnesses. Will with one witness is considered to be null and void in the eyes of law. You need to name those witnesses and state their addresses. Now, who could be these witnesses? These witnesses could be, it would be ideal if one witness is your family doctor, because the person would then later on, when the will is called in question, or when the person is going to obtain a probate, could testify that the person, that is the testator, was of a sound mind when he was making a will. So yes, a family doctor, a trusted friend. Likewise for the executor, you could have a person who is a trusted friend who is not a beneficiary to the will. Mind you, the person cannot benefit from the will to be the executor of the will. That is why probably a trusted friend or a chartered accountant. And yes, importantly, every page needs to be initialed by you as well as the witnesses. In case you are making any correction to the will, it needs to be countersigned by you and the witnesses. In the end, do not forget to date the will, which is another essential of a valid will. So yes, having said that, I believe I've covered more or less essentials of a valid will and the concept of will. Let me know if you found this information basic or good enough. Let me know if you wish me to go into further aspects of a will with regards registration of a will, probate, or any other topic that you wish me to deal with. Stay home, stay safe, have a nice day. Thank you for listening to this.